therapist. Welcome to another episode. I'm glad to have you. We're going to touch on a topic that is not widely discussed, but is still in effect and creates a unique conundrum in today's, overprotective, landscape over student information, private personal information, FERPA, HIPAA, GLBA, all those things that kind of, come into play. Today, our topic is the Solomon Amendment, understanding it and its implications on higher education, student privacy. For those of you that don't know what the Solomon Amendment is, it was a federal law enacted in 1996, and it mandates that higher education institutions receiving federal aid must provide military recruiters with access to their physical campuses and student recruitment information comparable to those provided to them by employers. The law essentially creates a very complex interplay between national security interests, individual rights, and privacy, and frankly presents very unique challenges and responsibilities for educational institutions. Background on the law itself: it was introduced as a response, to what back then was perceived as barriers that recruiters faced on college campuses, particularly during periods where there's heightened anti-military sentiment. And the purpose was to ensure that military careers are presented as viable options alongside other employment opportunities. So this was about access to information that allowed the military to market to recruit and advertise to, potential candidates. The law does require schools to provide directory information, which can include name, address, and phone number of students, unless the student had specifically requested that this information be withheld. A little update and a wrinkle on that, with guidance from the Department of Education. We can talk about that here in just a little bit. But compliance with the Solomon Amendment is extremely important because it's a prerequisite for receiving federal funds from various government departments, that align educational funding directly to military recruitment policies. So it's not really a choice. It's something that colleges and universities have to comply with if they participate in federal funding. Now, directory information, or what that means, or what the law gives access to, it consists of student name, address, telephone, age, level of education, and the degree that the student is attempting, or the program that they're training for. And the data as defined in the amendment is generally considered harmless, but can raise varying privacy concerns. The compliance requirements essentially look like this. Institutions have to notify students of their rights to withhold directory information under FERPA, and must comply with requests from military recruiters unless the student has opted out of such disclosure. So you essentially have to disclose to the student that the institution has to comply with the Solomon Amendment, but also give the student very specific rights to opt out of disclosing their information to military recruiters. The consequence for noncompliance is a big deal, right? Because it could lead up to, or it may entail, losing various forms of federal funding, which is a crazy penalty that can impact any institution, right? Its resources, its capabilities, and for some small schools, cease to exist. Its interaction with FERPA is also, very, very interesting, right? Because FERPA protects the privacy of student education records, which is what this amendment defines as directory records. The Solomon Amendment does override FERPA's protections if a student has not explicitly opted out of directory information disclosure. And that's the language that they want you to use, which creates a grave conflict between complying with a federal demand for, openness to military recruiters and protecting student privacy. So as an institution, you're stuck kind of in between these two places, and you have to administer the requirements very explicitly to be in a compliant space, right? You got to disclose, and you got to give students a clear option to opt out of this. Otherwise, you have to furnish this information to the military if they request it, right? There's a lot of different, case studies around this. Various institutions have developed different approaches, from strictly adhering to the minimum requirements to actively facilitating military engagements on campus. Some schools have faced criticism, some legal challenges, internally and externally, from students, advocacy groups, who argue that the Solomon Amendment infringes on student rights and academic freedom. Most debates have focused on whether stringent measures are necessary to ensure that military recruiters are not only given access, but are able to recruit effectively without undue restrictions. So it's somewhat of a polar, subject. You have proponents of the amendment that say military recruitment should happen unhinged. It should be supported and facilitated by the institution. And you have another side of this that say this is a clear breach of privacy and FERPA, and institutions should not facilitate these recruiting practices. But nonetheless, in summary, the Solomon Amendment is a federal law. It is an active law. It does allow military recruiters access to directory information, which is some address and biographical and academic information on students. To be a little bit more clear, the student has to be 17 and older, and the students do have the right to file what's called a FERPA restriction against the disclosure of this information to the military. But if they have not, the institution does have to provide it. To be clear, the Department of Education has determined that the Solomon Amendment does supersede most elements of FERPA. An institution is therefore obligated and must release the data included in the list of student recruitment information, which may or may not match the FERPA directory information list. For most institutions, the student recruitment information or the directory information looks like this: name, address, telephone, email address, age, their citizenship status. So are they a native citizen, a naturalized citizen, or a permanent resident, or a non-citizen? The level of education, the classes that the person is currently enrolled or registered in, and their major or program. So it's a pretty thorough, robust piece of information. Under the Solomon Amendment, the information is released for military recruitment purposes only. So that's to prospect, market to, or attempt to recruit those students into the military. And the military may request the student recruitment information once every defined term at the institution. So that's once per semester, once per quarter, module, right? For each of the eligible unit in the 5 branches within the military. So that's Army, Navy, Marine Corps, Air Force, and Coast Guard. The request is typically submitted in writing and clearly identifies the unit of service and, which branch of the military and the use case for this information. And the request is typically only based off of current term information or past term information. So this semester, this quarter, or last semester, last quarter, this mod, last mod. The information does have to be transferred securely. It's typically using a service provided for restricted data that can come from the military, or in some cases, the institution may have to provide that gateway. So again, it's something that's not talked about a lot, but it's very impactful. And you have to have a pretty solid, system of governance to comply with the Solomon Amendment. We find that typically larger state universities are the ones that deal with this frequently. Maybe small technical education colleges are not dealing with it as much, but it applies to all institutions that receive federal funds. Thanks for joining me for another episode. Look for articles and resource guides along with each episode to support you with more detailed information, resources, and action steps. Thanks. Have a great day.